Okay, so we were just talking about the compensation paragraph. So you, as I mentioned, you would include what Miss Applegate's compensation was going to be in her first year and then in her second year. Um, and you would, just adjust this language and make it fit accordingly to Miss Applegate. Okay. Now, it wouldn't apply. What I want to say is, you want to make sure you don't include language like providing sufficient profits are being generated from which to pay the aforesaid increases, right? She's not getting paid any other additional compensation other than her salary, which is what I said, no other compensation in the fact pattern. So that's how you know to remove that information from what you're writing in your contract in your Word document. You're not going to include all of this information. You shouldn't be including anything in these additional paragraphs because it doesn't apply. It's talking about percentage increases regarding other incentives and total net income. You shouldn't be addressing any of this. It should all be basically removed. All right, we're keeping this simple. I just told you what her employment. Let me slide this over a little bit. I just told you what her salary was going to be, and that's it. Okay, so don't worry about all of this that talks about profit and loss statement and net income and anniversary date and computation. Leave it out. If upon, for whatever reason, further negotiation between the parties, they wanted to add that, okay, we'll amend the contract down the road. But for right now, based on the information you have, you should not be including all of that information. Okay, so next up, just looking at the sample here, we've got upon employee's death, resignation, or discharge. All right. And then also here, just looking at the facts, we also have the employment relationship may be terminated at any time by either party upon 30 days written notice. Okay. So there's a fact that we have there, and we want to make sure we touch on that. So this is a perfect example where you need to look at both contracts and figure out, how am I going to write this? How am I going to draft it? So let's see. We look at this other sample contract, and there's one that says termination of agreement. Huh, that's interesting. Let's take a look at that. So you could do, to make sure you include this appropriate fact that I said should be included in the it should be included in the agreement, right? In the fact pattern. So we say, okay, let's have another paragraph titled termination or termination of agreement. And you would want to write the facts that are relevant. And we know that this is going to terminate upon the expiration of 2 years, because her contract's for 2 years unless it gets renewed. So actually, this language actually fits. This agreement will terminate 2 years from the date hereof unless terminated sooner as provided herein. That's great. And that's all accurate, and you want to leave that. And then you would also write this additional sentence. You could literally copy this this entire provision entirely, because it applies to the facts of the client's case, right? The employment relationship may be terminated at any time by either party upon 30 days written notice. And we just talked about that it would be for a 2-year period, right? Okay, so we want to make sure that provision gets in there. So you would include this termination of agreement as a paragraph, right? And again, whether you do it before compensation or after compensation or a little bit further down, that doesn't matter as long as the facts are included in your contract, okay? And you want to kind of, as you're going through the fact pattern, use a pen. Just check off the facts as you go to make sure you're including them in your contract, okay? So let's see. We have, and we already included the extension, the right to extend it at will when we were talking previously about in the section that was in the compensation section, right? So then we have, let's see here. Let's go to the next fact. So we already worked in her salary, right? No other compensation or incentives. So we know that. We got that in the compensation paragraph. So now we have here, upon Miss Applegate's death, resignation, or discharge, she will be paid any outstanding unpaid salary prorated as appropriate. All right, well, that is very similar to this paragraph here in this sample contract that says, upon employee's death, resignation, or discharge. Here it says for cause, but we won't include that because that's not relevant to the facts. We're going to just change the the terminology, because when you look at this one, it's not exactly accurate. Like these facts don't really apply, so we wouldn't be using them. But let's look at the other contract and see if there's any other helpful terms or phrasing that we can use. So here we have the phrasing of non-performance, right? So let's take a look at what that says. Non-performance. Should the employee, for any reason, become physically or mentally incapacitated from the performance of his or her duties as set forth herein, this agreement shall be considered null and void and shall terminate immediately. All right, that seems relevant. And we gotta, to some of our facts, we're gonna wanna maybe combine it with some of these facts. So, and let's go back to our sample. So, and our statement here was upon her death, resignation, or discharge, she will be paid any outstanding unpaid salary prorated as appropriate. All right, so we gotta be a little creative here and create a paragraph based on this information. So you could very simply write, you could title it non-performance. You could not title it at all. As long as the information is in there, that's okay. But it would be something along the lines of, upon employee's death or incapacity, this agreement will terminate immediately, right? Because that's death or incapacity. Or upon her resignation or discharge, she's going to be paid any outstanding unpaid salary prorated as appropriate, which is exactly what it says here. All right. And then it also says, here are some more facts. She will also be paid for any unused or vacation sick leave, right? So if she resigns or is discharged, she's going to get paid for any unused or vacation sick leave. Obviously, if she's dead, that's not going to apply. But you get it. You can adjust the language accordingly in a way that's going to be accurate, right? And that's what I mean when you use these documents as samples and you just try to combine sample language with your client's language to just make it, or your client's terms of their contract, to make it as accurate as possible, okay? And I know this is the first time you guys are trying to do this, and believe it or not, this is very simple, or this is a simple fact pattern. Oftentimes you're dealing with far more complicated situations in the real world. So again, I know it might not seem like it, but we are actually still dipping our toe in. We're diving a little more into the deep end than week one, which was a little bit much more of a basic assignment. But still, you're still practicing this concept of using these guides and applying your facts to them, and also being somewhat original in what you're writing, but very much using these sample contracts as templates, okay? So moving on, we talked about, just sticking with the fact pattern here, we already talked about there'll be no other compensation or no other interest. That should be included up in the compensation paragraph. We just did her death and prorated and unpaid sick leave. We covered that. So here's the next sentence. Should any disagreement arise as to the terms of this employment contract, the parties agree to arbitration and payment of the prevailing party's attorney's fees and costs by the losing party, but there will be no liquidated damages. Okay, I can tell you in looking at this other sample contract, there isn't really, this language isn't really that applicable to what's in here, but let's look at the other sample contract. And this one does talk about, let's see here, you want to read through it, look for similar language. Here we've got remedies. Interesting. The parties recognize that a breach of any of this says restrictive covenants herein, we would change to the terminology that the parties agreed upon, but it's not wrong to use the term restrictive covenants because basically that's referring to the promises in this agreement, that they are going to agree to enforce their remedies or basically litigate their dispute through, here it says binding arbitration. I just wrote in the fact part an arbitration, so you would adjust that accordingly, right? So you could adopt some of this language, and you could make it even more simple to simply say that should a disagreement arise as to the terms of this agreement, employer and employee agree to arbitration. And you can even combine it with, here's another sample of attorney's fees and litigation costs. There's another one down here about liquidated damages. You don't need to make these 3 separate paragraphs. Maybe that's not necessary, but you could just reference the paragraph as remedies, attorney's fees and costs, remedies, attorney's fees and liquidated damages, however you want to title it, and basically combine it to succinctly say that should a disagreement arise, with respect to this agreement, the employer and the employee agree to arbitration and the payment of the what does it say? And the payment of the prevailing party's attorney's fees and costs by the losing party. But there will be no liquidated damages. You can literally adopt what I wrote and kind of structure it into your contract, into a very relatively simple paragraph. And like I said, you can kind of combine, see how these things get titled, and make it clear as to what you're talking about. Be a little creative on your own, but also very much fall in line with traditional contract provisions, okay? So the next sentence says here with the fact pattern, the agreement supersedes all prior agreements and shall become null and void should Miss Applegate become physically or mentally incapacitated, and it cannot be assigned to a third party. All right, well, we've kind of already touched on physically and mentally incapacitated, right? We talked about that when we were talking about the non-performance paragraph, right? So you probably don't need, as long as it's included, you don't need to talk about it again. But the agreement supersedes all prior agreements and cannot be assigned to a third party. Again, we're checking off facts. We got to make sure we get them all right. And no, I wasn't just going to all write this in the exact same order that you could just copy paste it into the contract, because then you don't learn anything, right? The point is, I want you to kind of adjust and read through these things. And while I'm helping you along with it, I do also want you to think independently and think critically about how to write this in a way that would make sense for the parties to this contract, right? So, okay, we've already talked about physically or mentally incapacitated, so we can ignore those facts. But this word supersedes. Let's go into the contracts and see if the word supersedes in here. Let's see. Hold on. Where is my... Here we go. Where's the word supersedes? This entire agreement. This agreement constitutes the entire agreement of the parties and supersedes all prior agreements, understandings, and negotiation, whether written or oral, between the parties, right? This agreement may not be changed orally, but only by an agreement in writing, signed by both parties and stated as an amendment thereto. Interesting. All of that is relevant to what we just talked about. And actually, if we keep reading in the fact pattern, which is why you want to always read through everything before you start writing, read through the entire fact pattern, read through both of the sample contracts, because it says down here, no modification may be made except in writing and executed by both parties, right? So that's something that that would be accurate to include virtually this entire sample clause. You could include entirely in your contract, and you should, right? And again, then you could check off those facts are included in the language of my contract, all right? Let's keep going before I run out of time and have to do a third recording, because my 15 minutes are coming to an end. But we were talking about cannot be assigned to a third party, all right? I wrote cannot be assigned to a third party. That's a fact you need to include. All right, well, here's a phrase called assignment. Now, I know we're going to talk about third party rights and stuff this week, but you guys are smart. I have complete faith that you could put together, when I wrote this contract can't be assigned to a third party, you could look at particularly this sample contract and see assignments. This agreement shall not inure to the benefit of the heirs, successors, and assigns of the respective parties there hereto. Perfect. That's a clause that says this, very simply, this contract cannot be assigned to third parties. And you would want to include all of that language, because it covers, if Miss Applegate were to die, it doesn't go to her heirs or successors under probate law or her will. Bottom line is the contract would terminate. This contract is non-assignable. And you can see that sometimes there's a little overlap between the particular contract provisions, and that's okay, all right? It's better to repeat yourself than to not include something, okay? All right, so before we get to the next clause, I'm going to pause this and watch recording 3 next, okay?